Buckle up, because today's case is as volatile as it gets. We're diving into State versus Rashad Young, a case tangled in domestic violence allegations, jailhouse phone violations, and an explosive courtroom appearance by the alleged victim. Herself, Rashad Young stands accused of pulling a knife on the mother of his child during an argument that turned deadly serious. But that's not all. He's also accused of violating a no-contact order over 135 times while in jail by calling the victim, a move that's left the judge furious. And just when you think it couldn't get any more tense, the victim storms into the courtroom, begging the court for help instead of punishment before things completely spiral out of control. We've got allegations, denials, courtroom outbursts, and a judge who's had enough. This isn't just a hearing, it's a legal meltdown that you won't want to miss. Let's dive in.
Court calls the case to versus Rashad Young.
Alexander, on behalf of the people, Your Honor.
Defender appearing on behalf of Mr. Young. Approaching, state your name.
Rashad Young.
Your Honor.
Yes. Okay, if it's you, Ms. Senta, okay.
25,000 without the 10%. In this case, the defendant has a companion case in.
Whoa, rewind. The prosecution just dropped a bombshell. Rashad Young isn't facing one case. He's entangled in multiple domestic violence cases, all involving the same victim. From one court to another, a pattern is emerging, and the prosecution is using that to stack their argument for a higher bond. And this isn't just some heated argument, there's a knife involved. The stakes are dangerously high.
Misdemeanor Court 1482 from 2024. It's a DV assault with the same victim, and I believe her son. He also has a case out of Plymouth for a domestic violence with the same victim. And in this case, it is an FA with a knife in which he threatened the victim with the knife, took it out while they were arguing, pulled it out, brought it up, brought it down towards her. And while he was in custody from, I believe,
135 phone calls while in custody, and all allegedly to the woman he's not supposed to contact. That's not just a minor slip-up, that's an aggressive violation of a court order. In most domestic violence cases, contact violations are treated very seriously. This isn't just about ignoring rules, this is about safety and control. The prosecution's concern isn't just legal, it's life or death.
23 to 26, he made 135 calls to the victim, which was against the conditions of his bond, which was addressed at arraignment. We have great concerns for her safety as he keeps contacting her and getting new cases for domestic violence with the same victim. And we'd be asking that at this time his bond is set at 25,000 without the 10%. Into custody, Your Honor.
Response.
Okay. Regarding the actual charge, I did review the discovery myself. The evidence is solely the testimony of the complaining witness. There has not been any evidence of a knife. Regarding the phone calls, my client does.
The defense is pushing back hard, claiming there's no real evidence, just the alleged victim's testimony. They're also denying that Rashad made those phone calls. But here's the twist. The calls were reportedly made from his jail, pinned to her phone. That's not easy to explain away. The defense wants more time to dig through evidence. But with multiple red flags flying, will the court even budge?
Deny all of those allegations. We have not received a violation report to discuss that with him. I was going to ask for an adjournment because we have not been able to speak about this case. I was going to ask for a week adjournment so we can go through the evidence and possibly at that point we can, address bond again at that.
Pay attention here. The defense is asking for the defendant to remain out on bond with a tether. But given the multiple allegations, repeated contact, and now potential phone misuse, that's a big ask. Judges don't just weigh the charges, they weigh behavior patterns, and Young's alleged disregard for court orders is tipping the scales.
That hearing.
But he's indicating that calls were not made from the jail?
He's saying it was not him making the call. He did not make any calls to the complaining witness.
And I believe they were from his PIN to her number stated in the police report. And given that he already has multiple other cases with this victim, I have great concerns that he would still be contacting her out of custody.
I would ask, he is, okay, he is, your phone was. Did I give you the It is my understanding that he is gainfully employed. He is a father. I would ask if he is, he can remain out on bond with a tether.
Well, but I'm a bit.
You can hear it in the judge's voice. The patience is wearing thin. The calls, the mounting charges, and now the confusion over release dates and bond terms. It's a perfect storm. The judge is clearly struggling between procedural fairness and real concern for public safety. And when that balance tips, things usually don't go well for the defendant.
Bit concerned about all of this contact. I mean, I've got these cases coming up while we were at the bench so that it's clear. Prosecutors indicating to me calls are coming from the jail from up to the 6th when he's released on that day. But he's arraigned on the 4th, and it's clearly indicated he's to have no contact. So, and if it came from his pen, I mean, so I'll adjourn this to February 20th, 2025, 9 a.m. I'll adjourn it out 1 week.
Would we be provided with the calls?
Yes, I'll send those
Okay.
out or I'll send an email to have those released today.
I'm gonna set his bond at $25,000 cash surety as the amount. What was his bond set at initially? Personal?
I believe it was the 25,000 yard with the 10%. And then the other case, he got a nominal $100 bond on the mistaken case.
All right. So defendant's gonna be remanded. He'll need to post that. And then at this point, defendant's phone privileges, given what the court has heard, are revoked so that he'll go into the jail. He won't have phone privileges.
Boom, there it is. The judge just revoked Rashad Young's phone privileges in jail. That's not a common move, but in this case, it signals serious consequences. When a judge removes basic inmate rights like phone access, it's a clear message. This isn't just procedural anymore. This is about protection.
This is the court's intention. And then you can get those through with your client, and we can figure it out next week. But at this point, defendant's remanded. I'll recall the matter of the People versus Rashad Young.
Ally's on behalf of the people.
Oh, there you are. Okay, I didn't know where you were at. It's like,
Ashley Moulton on behalf of Mr. Young.
yes, and Mr. Young, he was taken into custody, transported down. He is not here. I'm not bringing him back up only because my understanding is the alleged victim wanted to address the court. So we could get her.
And here comes the drama. The alleged victim bursts into court, apologizing and pleading with the judge not to incarcerate Rashad but to help him instead. This kind of emotional plea isn't unheard of in domestic violence cases, especially when there's a long, complicated history. But judges can't just go off emotion. They need facts, timelines, and above all, safety.
Your name?
Tandiana Yates.
All right. Ma'am, I'm going to let you know, if it weren't for the people in the prosecutor's office and counsel, I wouldn't be calling your case back up, and you probably would have been locked up. I'm just going to let you know because you don't come into the court that way, ever. Am I clear?
Yes.
What did you want to tell the court, ma'am?
Okay, first I want to say I fully apologize for coming in here like that. I was unaware. I'm sorry. I just want you to know with this whole case, instead of incarcerating somebody,
Go ahead.
y'all need to try to help him. I don't know if the prosecutor let you guys know, but he has yes, I'm sorry. You can talk. I don't want to overtalk you.
Well, you'll never do that, but I'm just going to.
Watch closely. The judge's tone goes from open-minded to visibly frustrated. She's trying to listen, but she won't tolerate being lectured. Courtroom decorum matters, and bursting in with accusations about inaccurate information without proof, that's not going to fly, especially when the court says everything has been verified.
I'll let you know that I'm not going to sit here. You wanted to address something to the
Yes,
court.
because I felt like it was
I
inaccurate.
will listen to you. I'm not going to tell you or have you sit here and try to give me a lecture on how something should work.
Oh, no, I would never do that, but I just noticed when I was looking on the Zoom that it was inaccurate information stated on you guys' record, and I just fully disagree when inaccurate information is stated on something that's very important like this. With the prosecutors, they should have called me instead of giving out inaccurate information, because I would have just let you guys know. Instead, when I looked on that Zoom, it was inaccurate information stated on this, I don't know what you call, in this courtroom, and I just fully disagree with that, so I wanted to make that known.
Okay, let me just say this, because you kind of blurted that out when you had come busting in here.
And my apologies for.
So let me just tell you so that you can understand what you're saying and what is being said. Because when you said that, which is everybody's obligation here, his counsel, the prosecutor, and even in some respects the court, to double check what somebody is saying, in particular if a decision was made based upon inaccurate information. Let me tell you that the prosecutor, as with her duty, checked what you were saying. I don't think, at least preliminarily, and I discussed it with his counsel and with the prosecutor, that what you're saying is correct, that it was inaccurate. At least with reference to what I was using for my decision on the remand. There will be a hearing that will be set next week. At that hearing, all of that will come out. But at least preliminarily, it does not look like the information that was presented to the court was in any way inaccurate. Some of the information with reference to the date, so that you understand, the court itself can tell in looking at the file and when he was arraigned. So while you may have your position that it's inaccurate, I do not believe at this time that it is inaccurate.
Okay, so is there any way that a prosecutor, an actual someone can call my phone so we can discuss this? Because I no longer have that cell phone number, and it's to my sibling. You guys stated on.
If there are references to the case, ma'am, we thought about that.
Okay.
If there are references to the case, references to you, references to other things that are occurring. So I don't think, and I said, I have not made a final decision on it certainly, but at least preliminarily what is being represented to the court appears to be true. And we will flush it out at a hearing because that's the way our system works. Preliminarily, I have that. I took what remedies need to be done to enforce the orders of the court regarding no contact. It seems that that was violated. He will have his due process right to a hearing next week regarding that.
But how is it violated when I have not physically talked to him? Just like when I came into the courtroom the first time and I sat down, he made it aware that I can't even be around him.
I am not going to have a hearing on it right now. I will listen to you.
That's just very, that was just very inaccurate to me. And I just felt like the way that y'all did that was no.
Yeah.
Somebody should.
This is where it all breaks down. The victim keeps pushing, the judge keeps explaining, and finally, the judge snaps. "Don't turn your back on me," she says, before threatening to eject her. And then, she does. That moment is raw, real, and incredibly revealing. Judges have limits, and in this courtroom, that limit just got crossed. Asterisk, what would you have done in this judge's shoes? Should she have been more patient, or was she right to cut it off?
Y'all did what? Don't you turn your back on me, because I'm telling you what, you are trying my patience.
No.
You are trying my patience. I brought you back in here after you acted like that to listen to you. And then you're not going to listen to a thing I said. I'm done. If you want to attend the hearing next week, you can come to the hearing. I've tried to explain it. You are not listening. I am done. Do not say another word to me. Mr. Allen, remove her.
Nobody.
Remove her. You keep talking and there's going to be a problem. There's going to be a problem. Ms. Cannon, do you want your cases called now? No, I'm good. I am so good, Miss Candy. Are your people here? Oh, well.
Yes, Your Honor, they are here. They are ready and they are eager to just listen and learn.
And just like that, the courtroom returns to order. The chaos settles. The next case prepares to begin, but the tension still hangs heavy in the air. What started as a bond hearing turned into a full-blown courtroom standoff. And with the hearing set for next week, we're only getting started.
This honorable.
In State versus Rashad Young, we saw allegations of physical violence, a judge balancing safety with fairness, and a courtroom that nearly lost control. With multiple open cases, a revoked bond, and a dramatic no-contact violation, Young's legal troubles are just beginning. But it's the human element, the raw emotion from both the defendant and the victim that makes this case unforgettable. The hearing next week could change everything. If you found this case as shocking as we did, make sure to hit that like button. Share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns. We've got more real stories, real drama, and real justice coming your way.